Is there just Sarah on the phone, or?
Yes. Are there any other board members besides Sarah LaFay on the phone? Sounds like it. So we're still waiting for one board member to reach a quorum.
7, 8, no, 2?
Well, I'm one, right?
Oh, yes, that's
It's usually here.
Oh, here we go.
Oh, wait.
That'll be $5.
Sorry.
There's already donuts in the room.
The name isn't even here.
$5.
We don't even have a name tag for Jake.
I'll be Brett today.
There you go.
You're Jacob Hadishaw?
Yes.
Oh, yeah. I remember your face. Greg Mitchell, yeah.
Or you could be Donna. Maybe you just totally removed even so much. Could happen. Could have done.
Are you ready? Yep. Okay. Good morning, everyone. Calling the meeting to order of the Workers' Compensation Board. Today is January 24th. It's 9:07 a.m. We're at 3301 Eagle Street in room 208 in Anchorage, Alaska. This is a public meeting. Notice was posted in the online public notice system on December 24th, 2018 to meet the 30-day notice requirement under Alaska's Open Meetings Act. Just a few ground rules before we get started. If you have your cell phone with you, please put it on silent mode. We are recording the meeting, and it will help everyone participate if we speak deliberately and clearly into the microphones when we're addressing any issues before the board. The meeting will follow Robert's Rules of Order to help keep things respectful, organized, and efficient. We do have periods set aside for public comment, so people will have an opportunity to comment not only on the proposed regulations, which will be our first order of business for public comment, but also later on to raise general issues for the board to consider. We'll open the meeting with one of my favorite things, Pledge of Allegiance, if you could all stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. First order of business is to do a roll call of the board members, and I'll just pause for a second because one of our members is grabbing a cup of coffee.
Can I ask a quick question?
Please identify yourself.
Oh, sorry, this is Sarah LaFave.
Oh, yes, certainly. Go ahead.
So in the emails, there was the draft minutes and a draft agenda, but not a full board packet that I'm seeing. So you must have a packet there that has more documents in it?
Yeah, sorry, Sarah. I'll send that to you right now. This is Alexis.
Okay. Great. Thank you.
Okay. Well, I'd take a motion for a brief recess while we get the meeting packet to Sarah LaFave, if one of the board members would like. Second?
Second.
Any objection? Okay, we'll take a 5-minute recess and reconvene at 9:15.
Yep. Okay.
Doesn't like my finger either.
Yeah, it doesn't like your finger either. Just keep holding. There you go.
Oh, I got it?
As soon as it goes gray here.
Okay.
Super.
For those of you in the room, if you do wish to make public comments, there is a sign-up sheet right by the door, and if you would like to make yourself known to us, that would be great. There is some refreshments next door. If you want to take the opportunity to fill up your coffee cup or grab a donut while we're waiting for the packet to be delivered to one of the board members, Sarah.
Jake, did you come down for this, or were you here for something else?
No, we've got a foreman training going on at our two guys training school.
Oh, nice. That's such a nice facility.
Yeah, we'll go. You ever been to our training school in Fairbanks? It's a box. We built that. The art in Fairbanks we built out of pocket. And with, you know, apprentices tournament. This one here, they just, there's 15 million, go build it.
It's quite,
College campus.
they have dorms and everything. If they do that at our here.
Yeah, it definitely makes bringing people in from rural areas a lot easier.
Yeah. And the other people have to find a room or family. If they've never been here, don't know anything. You can get accepted. If we had classes year round, I'd buy it. Like a 4-bedroom house and make it make some cash on the side. But we don't have them all year.
But you guys end up doing whole big blocks.
When we're off.
Hello, for the
right now.
person who just joined us on the phone, we're on a short recess and we're going to be reconvening here in just a couple of minutes.
Oh, did you? Yeah. Might get something important now. Yeah.
Oh, me too.
Well, that's good. Alexis is covering the bases.
Yes. I'll just close this and do it on my phone.
Yeah.
So much easier to look at.
Are you talking about the budget spreadsheet?
We were just talking about the board packet being distributed among all the board members.
Oh, okay.
I got it.
Okay, do you need time to copy it? Or,
I have time. It's no problem.
okay. Okay, we are back on the record. It's 9:15 a.m. And we'll move along to the next order of business, which is a roll call of the Workers' Compensation Board members. And I wanted to start with myself. I'm Gray Mitchell, the new director of the Division of Workers' Compensation and the Commissioner's designee on the board. And so now I'll go through the rest of the members. Brad Austin.
I'm here, and for your information, I'm a labor member.
Got that?
It'd be nice to let Gray know looking for labor industry.
Thank you. Pamela Klein.
Here and labor, right?
Okay. And Chuck Evans, not here.
Brad.
Colin?
Chuck Evans.
Brad Evans.
Chuck Collins.
Brad.
I'm just going through the list of...
Yeah, Bradley Evans, we have a Chuck Collins.
Oh, it's not Chuck
Yeah.
Evans. Oh, we have a typo. Chuck Collins is here.
Mr. Gray, I'm here
And,
representing industry.
nice. And Brad Evans? Not here. And Bronson Fry is excused. Jacob Howdeshell was excused but is here,
Here, labor.
representing labor. David Kester is excused. Sarah LaFay.
Here.
And Sarah, do you represent labor or industry?
Industry.
And Coney Latua Nasanoa is not here. I practiced that.
I think you did it perfect.
Justin Mack is not here. Linda Murphy
Here, representing industry.
and Donna Phillips. Nancy Shaw and representing industry, labor. And Amy Steele.
Here, industry.
And Brett Stubbs is excused, absent. Rick Cheney is absent. Robert Wheel
Present and representing industry.
and Lake Williams is okay. We were picking up some static on the phone line, but it seems to have resolved, so we'll continue on. We do have a quorum, which I'm told is 9 plus 1, so we do have 10 members for the board available to do business. The next item of business is to adopt the agenda, approve the agenda, and all of you were provided a meeting packet, which has several tabs in it. The first page is the table of contents. Tab 1 should be your meeting agenda tab. Tab 2 should be the meeting minutes from the previous meeting. Tab 3 is a listing of the Alaska Workers' Compensation Board members. Tab 4 is a list of the board designees for the Workers' Compensation Division on the board. Tab 6 is an organizational chart and several budget document. Tab 7 is a list of the proposed regulations, and tab 8 is a list of workers' compensation cases over the last year that'll be involved with our review.
I would make a motion to accept the agenda as stated.
Okay,
Second.
and is there any
Hey,
objection?
this is Alexis, and since I'm taking the minutes, could everybody say their name when they make a motion so that I can get it on the minutes?
Member Wheel made the motion.
Member Murphy seconded.
All right, thank you.
Are there any objections to the motion? Okay. Hearing none, the agenda is adopted. The next item on the agenda is approval of meeting minutes. This is tab 2 in your packet. Can I get a motion? Is there any discussion?
I would make a motion, Member Wheel, to accept the minutes of the October meeting as presented.
Member Austin, I'll second.
Can you hear that, Alexis?
Yep, I got it.
Okay. Is there any discussion?
For some reason, on Thursday, October 4th, it says that Member Klein was absent. I don't recall being absent, and I looked, and all of that seems familiar, so I don't think that is accurate. I think I was here. Pretty sure I was here.
Okay.
I think maybe I was a few minutes late.
Okay, I'll note that.
Thank you.
Any, can I have a motion to amend the meeting minutes?
So moved, Member Wheel.
Okay.
Seconded,
And-
Member Austin.
And just to clarify, the motion would strike the words and Klein and change the word were to was on the first page under section 2 of the roll call provision or the part of the report.
And then adding her name to those present.
And adding her name to those present, that's correct. Okay, can I get a motion to amend the meeting minutes as I just stated?
Member Wheel, so moved.
Member Austin, second.
Any objection to the amendment? Okay, hearing none, the minutes will be adjusted. And so can I get a motion to adopt the meeting minutes as amended?
That's not necessary.
Not necessary?
That's already on the
Point of
floor,
order.
but it's, you need to vote on the main motion as amended.
Okay,
You just don't need another motion.
okay. I guess we're ready for the question then. Is there any objection to accepting the amended minutes as discussed? Hearing none, the amended meeting minutes are accepted. And for those of you who don't know, just a little clarification, I did sort of peruse this. It's called a complete idiot's guide to Robert's rules, but I am not an expert, and so I will hope that you will, call a point of order if you see me doing something that's completely off the mark. But in general, the rules are in place so that we can have an orderly meeting and that everyone gets the opportunity to participate and that we keep things organized, and so that's that. The next item on the agenda is the director's report. And so I'm going to start off by recognizing some key staff for the Workers' Compensation Division. Dee Ford has joined us today. Trying to find her. Nope. Oh, she must have departed already. Okay, Ron Ringel, of course, is our acting chief of adjudication. And again, I am just starting, and so I'm still learning all of the people that that assist me in the administration of the Workers' Compensation Division. And so I have some people on my list. I know Janelle Wright is in the room, a hearing officer. Bill Sewell, are you here? Okay, he's not here. John Yo is a hearing officer with us. And have I missed any hearing officers in the room? No? Okay. And Rhonda Gerhardt is here. She's the chief of the Special Investigation Unit. Beth Tustin is there. She's the chief of our reemployment benefits section, administrator. And then is Grace here? There's Grace Moorfield, Workers' Compensation Officer. Who else am I missing? Go ahead and introduce yourselves, please.
Oh. Felicia Lopez, I am a Work Comp Officer 1, so for this team.
Sam Wolfenden, Work Comp Officer 1, for that for me.
Anyone else with the division?
Thanks, everybody.
Great. I will get this right. I've explained to everyone that I meet that I'm pathologically challenged with remembering people's names, but I do make extra efforts to do it, and it helps to have your nameplate in front of you. So I will do my best, but please correct me if I make a mistake. First off, I wanted to thank all of you on the board. I have some experience with the commitment that you make to be part of the Workers' Comp Board process, and it's not an easy board to sit on. You deal with some complicated cases and controversial subject matters, and working with sort of opposing parties and difficult situations where workers have been hurt and employers are trying to figure out, how to resolve issues related to the claims that have been made. And so anyway, I wanted to just recognize that and to thank you for the work that you've put in as members of the board. And I know that, the little compensation that you get doesn't at all cover your efforts. And so again, thanks on behalf of the people of Alaska. Thanks for your commitment and willingness to serve. There are 8 board member terms that are expiring March 1st, 2019, and I've been told that the governor's office, boards and commissions, has been making contact with people and letting people know. I don't have a formal announcement about who's being retained and who hasn't, and so I'm leaving that up to them to make that announcement. One other reminder with the service on the board, there is a filing requirement to the Alaska Public Offices Commission, and that deadline is coming up for the 2018 report in March. I think it's March 15th. You can file your report online, but we tried to make it a little bit less painful, more painless. So you can file it online, and they do have a hotline if you have questions about it. And so don't forget about that. If for some reason your term ends, there's a little bit of a different rule for filing your final APOC report, but something to keep in mind. As far as staffing right now, there's an organizational chart. It's tab 6, and it shows all of the positions in the division. You can see we have 3 vacancies. It's the chief of adjudications position, which Ron Ringel is currently acting in. And then we have 2 hearing officer 2 vacancies, one in Anchorage and one in Fairbanks, although I'm not sure if the one in Fairbanks shows on this report. But as of January 22nd, Kelly McNabb is not with the division anymore. And so now I'm going to turn it over to Alexis Newman, who's the administrative officer for the division, to go through the remaining pages under tab 6, which are the a budget update from Alexis. Go ahead.
Okay, so for the org chart, right now we only have 3 vacancies, which is pretty good. We have the Chief of Adjudications position that's vacant, and currently Ron Ringel is acting in that position. And then we have 2 hearing officers, 1 in Fairbanks and 1 in Anchorage, that are vacant. We had recruited for the Anchorage position, and we were almost about to fill it when the administration changed, and so that recruitment was canceled until we can fill that chief position, because it's difficult to fill the 2 hearing officers when there's no chief appointed. But other than that, we're fully staffed and everything's running really smooth. So for the budget stuff, we're pretty much right on track with all of our expenditures and in all of our funds. There's really not a whole lot that's notable at this point because we're only halfway through the year. But if you guys want to take a look at those spreadsheets for a second and let me know if you have any questions.
Did you want to just cover the sheets quickly, Alexis? Just go through, what each sheet represents?
Sure. So the first sheet is a division-wide report. So this includes all 5 of our components: the Workers' Comp component, Appeals Commission, Benefits Guarantee Fund, Second Injury Fund, and Fish Fund. And it's kind of a roll-up of all the expenditures in one line. The second one is a detail report of just the Workers' Comp component. So it shows by line item what we've spent so far on personal services, so payroll, what we've spent so far on travel, our services and commodities, and any equipment that we've bought. And also the grants line is the benefits that we pay out. For this component, it's for those, there's like a handful of cases where the board pays the benefits on them, and so we're just waiting until those permanent disability cases go away. And if you might notice in the personal services line, we are projecting right now a negative balance of $67,000, but that is for our, what's it called? Vacancy factor, which means that we assume that we will have vacancies that will total to the amount of $60,000. And if we don't, then I will have make some room in the budget somewhere and move money from services to personal services to cover that. In the Appeals Commission, we're also showing a negative balance here, and that was due to a late performance evaluation, which affected a pay increase.
Just a second, Alexis. So this is at the bottom of the page, above the date, it would be 022. That's the sheet that...
Yes.
So it's actually the 3rd page of the budget spreadsheet material.
Right.
Go ahead.
Sorry about that. Yeah, on base stamp 22. But again, this component, the Appeals Commission, is still projecting a balance of $89,000, so that's nothing to worry about. Next page on base stamp 23 is the Benefits Guarantee Fund. This fund is also doing really well. At this point, it's not looking like we will need to do an increase for benefits, but we will know when we get closer to the end of the fiscal year if that needs to happen. And Second Injury Fund, this one is also projecting a balance for personal services. And, I guess I should have mentioned that on the org chart. We did a reclass of one of our positions. If you want to flip back to base stamp 19, the org chart, you'll notice that we have that administrative assistant 2 position back underneath me on the org chart. So that position, it was previously a technician under Velma, and that position was in charge of processing all of the executive officer waivers. And they also...
Sorry, Alexis, to interrupt, but this is the position that has the double box around it, Madison Gambala.
Madison Gambala, yeah. And so with HB 79, the executive officer program is ending, and Second Injury Fund is being sunset. and this position was pretty much dedicated to those two programs. So we were able to assign some additional duties to kind of round out the position, and we were able to reclass it up to an admin assistant too. So we essentially reinstated the position that had been cut last year. But so that reclass didn't happen as fast as I thought it was going to be happening. So there's a negative balance in the payroll of the second injury fund because, but again, we'll just, move some line items around and that'll be fine. And for Fisherman's Fund, again, it's projecting a positive balance of $23,000, so that fund is also looking good.
Any questions about the budget information that Alexis presented? Okay. And I'm not sure whether, I guess Alexis or Ron wants to do this next part, but the tab, we would move back to tab 5. Why don't you go ahead with that, Alexis, since we've got you on, and maybe it's not tab 5, it's tab 6. Which, I'm sorry.
4?
Tab 4, there you go.
All right.
And this is the list of designees for the board.
So I think Jung is the only new hearing officer who has been hired since. He's the only one that's new that you need to approve. And then other than that, we've had a couple people drop off the list. So that would be Kelly McNabb and Henry Pullen. I can't remember if he was gone at the October meeting by then or not. I can't remember when he left. But anyway, so yeah.
Okay. Are any questions for Alexis? Yes, go ahead.
Well, for Alexis or possibly for you, Director, are there likely to be any restrictions on filling those vacancies? I remember when I heard that Henry was leaving, and I was thinking, oh my gosh, this is a terrible time for that because you might not be able to fill unfilled vacancies in the future. What do you see for that?
Yeah, Board Member Shaw, this is Gray Mitchell, and I know that we don't have a hiring restriction right now. Of course, anything can happen at any time, and so there's no guarantees. But at this point, the administration has not signaled that is, going to be one of their efforts. And hopefully we would be able to convince them that such a hiring freeze wouldn't necessarily be productive at saving general fund expenditures, because this program is funded through fees that are generated under the workers' compensation insurance program. So I feel fairly confident that we won't be impacted, but it is a viable concern, so thanks for bringing that up. Any other questions from the board? Okay. Hearing none, I'll move along to the next section. Do we need to take a break?
There is one scheduled at
Right,
10 o'clock.
And really quick, I think we need a motion to approve the designees.
Okay.
We do.
Can I get a motion to approve the designees outlined in tab 4?
I would move that we approve the designees on stamp page number 15 as shown in the packet. And this is Member Collins.
Second, Member Murphy.
Okay, any objection?
Quick question for clarification, and actually that goes back to bait stamp 19. Under Chief Adjudication, Susan Righteous O'Brien has a double line square as well. Is she filling 2 now, or?
No, Alexis, you can clarify that, but I believe that the double line signifies supervisors.
Right.
Okay.
Yeah, so everybody that's got a double box around them is a supervisor.
Okay. And, okay. Was Susan always a work comp 2 officer? Was she?
Yeah.
Okay. Sorry, I didn't have that clear in my mind. That's it, thank you.
Just to add on as clarification, but on the designation below, you know, Fairbanks and SU or Juneau and SU, that SU stands for supervisory.
Oh, I see what you're
So
saying. Got it.
It gives you a little hint.
Got it.
Okay, with that additional discussion, is there any objections to the motion to adopt the board designees, on plate number 15, tab 4? Hearing no objections, that is adopted. The next item up for business is, notes here, a follow-up on the report from the director, which is a legislation update. As you all know, the division is currently implementing House Bill 79, which passed in 2018. Most of the provisions have already taken effect. I'll just cover it quickly. The regulations that we'll be evaluating later in the meeting primarily have to do with clarifications related to House Bill 79. But what the bill did was it added a clear definition for the terms independent contractor and employee. It allows for electronic reporting of workers' compensation data, allows employers to pay benefits by direct deposit, improves funding adequacy for administration of workers' compensation programs by increasing the percentage of the premium tax that's allocated to the Division of Workers' Compensation, streamline settlements by eliminating requirements for the board to approve attorney's fees as part of the settlement when the fees are the only settlement issue that requires board approval, phases out the second injury fund. No new claims for injuries or deaths after August 31st, 2018 will be allowed. Ongoing claims for SIF reimbursements for injuries or deaths that occur before that date have to be made by October 1st, 2020. And the SIF will continue to pay ongoing claims until those are fully satisfied, but ultimately the number of claims will reduce over time down to nothing. Updates, the bill also made updates to the medical fee schedule reference material under AS 2330-098. It simplified the corporate officer waiver process, which is the one thing that's still hanging out there in terms of an effective date. That will take effect August 1st of 2019 and will apply to policies and contracts entered or renewed on or after August 1st of 2019. And that one also requires a 10% ownership standard to be considered a corporate officer. Created an interim legislative working group to review the workers' compensation system. That working group did meet one time on October 11th and was supposed to issue a report by December 1st of 2018, but did not do so. The working group terminates at the end of this month, January 31st, 2019. So I suppose it's still possible that a report could come forward, but at this point it doesn't look like it. There's one other bill that I wanted to make you aware of. The Representative Josephson had pre-filed House Bill 30 on January 11th, 2019. This bill is very similar to House Bill 38, which was introduced last session, and in that it increases the PPI benefits, permanent partial impairment benefits, and death benefits. It's nicknamed the Abigail Caudle Act, which is a worker who was electrocuted a few years back, and her mother had made efforts to file a workers' comp claim, which was ultimately determined by the Supreme Court to not have validity. And so this bill, essentially, part of it anyway, tries to address that issue and creating a death benefit for the parents of a worker who's killed on the job when that worker does not have any other dependents. And so just a real brief overview of what that bill does. It changes the permanent partial impairment benefit from $177,000 to $255,506, which you might wonder where does that number come from. It's if you adjust for inflation, there's an inflation calculator, and if you punch in $177,000 and move it forward to today, it comes out exactly $255,506. Another provision is upon employee's death, the employer would be required to provide notice to the employee's estate of the time limits for filing a workers' comp claim and where to obtain a list of attorneys and grief counselors. This provision is a little bit difficult because there's no definition of what constitutes a grief counselor, and so there are some issues still with certain provisions. The aggregate death benefit would increase from $20,000 to $100,000. There would be a new death benefit for a parent of a deceased worker who has no dependents at the time of injury, and that is $120,000 in total benefits to the parents or the estate. It increases the duration of the indemnity benefits for children, dependent children, for 5 additional years. And one of the most substantial differences that House Bill 30 has with the House Bill 38 from the last session is that it would create an amendment to the exclusive liability provisions in the Workers' Compensation Act and allow an employer to be sued in the event of a worker's death caused by the employer's willful disregard of the employee's life, limb, health, or bodily safety. It's currently only an option if the employer fails to provide workers' compensation coverage. And that, of course, connects right with the Abigail Caudill incident. The bill would have a significant price impact. We have asked the National Council for Compensation Insurance to do an evaluation of this bill, but they had done an evaluation of House Bill 38 and estimated an impact on the workers' compensation market of $9 to $10 million. Just the state of Alaska alone, which is self-insured, had estimated over $500,000 in costs associated with the bill. So it probably will face some uphill challenges in the current fiscal climate. And so at this point, we are at a period of break. Does anyone have any questions for me based on the report that I just provided? So after the break, we have a public comment period designated for the proposed regulations. And that period is scheduled to last from 10:15 to 11:15, and this is specific just to the regulations. If there are commenters who want to make public comments that don't relate to the regulations, but just issues for the board to consider, then we'll have a period immediately following that for additional public comments. So for people who have signed up, just keep that in mind for the first hour, and this has been designated, and it's part of our public process to have this hour set aside for people to make comments specifically related to the regulation proposal. So keep that in mind. And generally, the comments will be limited to 2 minutes. However, if there appears to be room, we'll allow some leeway with that. With that, I think it's time for a break. Do we normally take a motion to do a break, or is it just, let's take a break? Okay, well, I like the idea of just keeping it informal. So we'll take a break. The public comment for the regulations is scheduled to start at 10:15. So right now I'm showing each of these clocks is a little bit different. I'm going to go with my iPhone time, which is 9:49. So we'll start in about 25 minutes with the public comment period. Thanks. We're off the record. Wow, that's a lot.
like your thumb much easier.
Every hearing started at 8:32, ended at 8:32.
Yeah. We don't get very many of those.
No.
Hi.
I'm Mike Jensen.
No problem.
Just wanted to say hello. Welcome.
Appreciate it.
I am.
We're gonna have.
Okay.
Back to our sleep.
Oh.
Me? Sure. Thanks for iPad. What's your next one?
I had a letter that I wanted to do
Oh, really? I believe it's conflict. Yeah.
I'm not looking forward to it. I think one day, they said it's a full day for her. Oh.
Yeah.
She came with a husband last year. That Tuesday. They signed a call for the wall over here.
No, I will.
Okay. Oh, he was? I thought I saw him
Oh, my goodness, yeah. It's mostly temporary, across the river, but, oh, there it is.
You know, I signed up for this, I was sitting in there when it. So is this the same review that we've got in here?
Pretty much the same.
I will probably still go to this.
Bill, because Bill was gonna do that. Because I'm still doing a whole load of hearings.
Just wondered if I should, I mean, I already paid my $25, I probably will go to this anyway. So you can get a postcard.
Call up the bar, so I hate this, and, this is earthquake, and, that's the goal.
Yeah, and I won't be, on the board anymore.
Well,
My mom was back there. I grew up in
Where Charlotte, I was on there, I was on. All, one minute. Where, you know, my wife, nobody's there. Nobody's there. I can't get a hold of anybody, and I'm like, if that's the word. Oh, yeah. You know, well, I don't, yeah. Oh, yeah. That's an easel, that was cool, yeah. Well, oh, yeah. That's weird. Directors. I like that.
I know. All those doors are not maybe back in March,
She's doing on her own, Well, I did with Bill for a while.
Hi.
Maybe I go back over the regard and find something over there. We decided to go up.
Oh, yeah.
Yeah, we don't, if I don't hear, if I don't hear from you. If you don't hear anything, that's good. Thank you.
Now I have all of these. We have, first quit working. Properties. I have to set the thing, watch certain things. Well, we've had a good system. Video recorder and everything. Russian Jack, and they broke in. It broke in.
Find somebody that will do it.
Somebody got checked into the hospital yesterday. She's got the flu.
Oh, no.
And dehydrated. Yeah.
Drive them in, right?
Yeah.
My Pomeranian.
Really?
If I get.
Somebody that took all of them out.
I trail myself. So if they see me get mad,
Yes.
they start trying to climb my way.
Oh, yeah.
Drive bananas. Go figure. You know, I would think if it was a chunk of beef or something, yeah.
Anyway, so remind me, I gotta call.
You better call down there and make sure she's okay.
Yeah, I'll call her I'm gonna call her. She's doing good because she's perturbed that they're gonna keep her 2 days.
If she's preferred, then it's going well.
Yeah.
Probably.
Yeah.
Probably it's
2 liters.
Yeah.
Yeah.
I was gonna say, she's probably a 4 load.
Yep.
Okay, a few minutes.
You're not still on the safety advisory council, are you, Jake?
No, that lasted a couple of months after that.
Oh.
Well, when I got on here, I was concerned that there was conflicts on being 2 boards at the same time, in the same department, so.
One of our guys said, dark-haired kid? That is Mac.
Risk management.
I'm sorry to tell you, what do you have to do it?
Well, he came over to look at his own house.
Yeah, probably so, right, yeah. You have a car?
I do.
I'm sure. He's okay. He's not really big. He's a big guy. Okay, because Gina Vick is okay.
Yeah.
He's taller than him. Yeah.
but it's a lot, but one of my guys, he was working on something for the boiler. Or something, I think that's when he came over, looked at it, and ordered a part. With a boiler right down, and then go down. But we had a stove out there. Hey. I guess it was right or something. I wasn't called over to work on that, so. There's just, when my guy told me that, I was like,
Chris took a job as a maintenance, yeah.
We thought he was on the great. That's bad.
Well, he's one of those, well, it's one of those guys. Which is troubleshooting.
The rate to get along with.
Yeah.
Why did you, we kept asking, we kept telling them, yeah, we kept asking. Right. Right.
I think they'll be waiting for it. Exactly. But they updated it, and Gino's good, but he's gonna, we do. Great. He's gonna start back, he should be starting back there again.
Yeah.
We loaned him out from there, so sewer treatment. So that's all done.
Yeah, I was like, we had some training work we've been waiting to do. Well,
so they do have those.
I know, given the size of the and quorum in my house, that we
Yeah, and he has.
So even if you weren't
he had a travel with
some way that he could.
But he's got one good
Yeah, necessary, I don't mean to be, but it just, you know, the move it takes me through this, I had no idea this was gonna move till it did. Better arrangements. No, I mean, touching on your own.
Well, it was my fault.
Well, government, that actually, yeah. I started.
Well, hopefully, you know, it's a one-time thing.
Yeah.
It just, you know, I was, you know, and I had already had server conflicts. So, basically my option was to try and have someone do it. Or see if we could get enough people to, you know. Because I'm really glad that meet the board and
Welcome aboard, all these things that I can, I just wanted you to borrow that one, just, if I could say it, I would, but we made the reservation, counted down the instant and everything else, and then, of course, if it's made like this, it's gonna be horrible. There was my sister's flight from Fullerton, California, to go skiing, and so I got rooms down there and everything else, and of course, the weather looks like this. It's hard to say, yeah, what you know, something. Yeah, you never know, all you got, the great thing about Alaska, you can be gone 10 minutes away and it's a different weather pattern than what you just left, so, yeah. But anyway, no feel one, and everybody's got my cell number, just if you've got, I'll definitely have my cell phone with me. Okay, all right, good. Yeah.
I'm not interpreting this correctly. They state that something has to be filed, and they state that they use Electric Standard Time.
Mm-hmm.
When I was in the summer where daylight savings time, clock standard time, should it just allow the time and
Still
not
have you
standard time?
looking for the apprentice program, or?
It's worth bringing up.
I mean, I just don't want to go over somebody to.
Since I went to like a minute before the five.
Yeah.
If
it wasn't,
it's actually. So it'll be back up to like eight, which is good. But it's down to 5.
Training center up here too, somewhere too, or?
Well, Anchorage has their own, yeah, there's 3 locals.
They all have their own?
Yeah,
Oh,
yeah,
okay.
Tech. Or, Fairbanks. They have
That stuff like they did out at the airport?
Yeah. We do. Bring the, put them in first. We do a lot of it back and forth, knowing each other.
Stuff the other day.
Yeah.
One of the guys said something about yeah, no, I. No, it's all one. But that's
What you guys doing here? Do you have a party?
So they're gonna take those first. Yeah.
We're at the 2-minute warning according to iPhone time, so if you need to get a cup of coffee or do something, just that's the warning bell is ringing. Comment on both regulations and others, all right. Do one on regulations first, and then comments later. Yeah, we should focus all the comments for the first hour on, regulations, and then if we run out. Yeah, well. Comments on regulations, then we can move into general, but first, it should be separated. Yeah, that's right. What I told Okay, it's 10:15 a.m. Calling the meeting back to order. We are missing one board member who I can see. Sending out a search party. We want to make sure that we have our quorum available. He'll be with us momentarily. A couple of comments about the public comments that we're going to be taking on the regulations from 10:15 to 11:15. If there are members of the public who are signed up to provide comment to the Workers' Compensation Board, please just comment on the regulations during this 1 hour period. If we run out of individuals who want to provide comments, then we'll move along to a general comment period. But this is really specifically, this hour is set aside specifically for providing comments on the proposed regulations. And as I said earlier, we generally limit the presentations to 2 minutes. So far, we do not have a significant number of people signed up to provide comments. Can I get a feel for how many people on the phone would like to provide a comment? If you'd like to provide a comment on the phone, please just state your name.
Hannah? Can you hear me?
Brian?
Was that Tama?
Hannah.
T-A-N-A.
N-A?
Yes, sir.
Okay. And Brian? Is there anyone else on the phone that intends to comment on the regulations?
Yeah, Eric?
Eric? Okay. And before you actually provide your comment, we'll take your full name and spelling, but is there anyone else, and it's fine to just give your first name, just so we have an idea. Heather?
Yes.
Okay, anyone else? Okay, hearing none. We have 9 people total, 8 people actually signed up to testify, so I think we can allow some leeway on the timeline for comments, but still, please keep your comments as organized as possible. You know, the board is certainly interested in hearing from members of the public, you know, but to the extent that you can target your comments and sort of follow a pattern, it will be more effective for the board. So we'll start off on the phone, and Tana, if you could just provide your name, your full spelling of your name, and if you represent anyone, it's okay if you don't, and then just go ahead with your comments about the proposed regulations.
Okay. My name is Tana Noe, T-A-N-A, last name N-O-E. I was injured back in 2015, and I am not a very good public speaker, but I'm going to give this a go. And first of all, the website needs to offer...
I'm sorry, Ms. Noe, if you could talk just a little bit louder, I think it would help.
Okay, I'll try. I was injured in 2015, and I'm not a very good public speaker, but anyway, on your website, there needs to be more information to work with your website. Technical information is not really user-friendly. Even with an attorney, it is hard to understand the information and process, making it hard to make decisions on what I should do in my case. And I do have an attorney, but I don't feel like it's a good attorney.
Ms. Noe?
Yes.
I'm sorry to interrupt you again. Do you have any comments on the proposed regulations? If not, I just ask that you hold your comments until we'll have another opportunity as soon as we get done taking the public comment on regulations to have general comments, and we'd certainly like to hear from you about improvements we could make to the website or other issues that you might be having. So do you have anything else on the regulations specifically, or should we move to another person?
Just move on, please.
Okay, we'll come back to you. Okay, Brian.
Yes.
Could you please spell your name for us for the record?
Absolutely. My name is Brian Zematis. That's BrianZematis.
Okay, and go ahead and if you represent anyone, you can provide that, or if you're just representing yourself, that's fine too, but just go ahead and provide us your comments about the proposed regulations.
Thank you. I'm not representing anybody, but my background, some folks over there might recognize the name. I used to work at the Workers' Comp division as a Workers' Comp officer 5 years or so previous to my current job, where I've been a claims advocate for an insurance brokerage in town, helping employers work through claims that they may have, and also advising them on any type of workers' comp claims and how to navigate the workers' comp system. So I wanted to comment specifically on the repealing of 8 AAC 45890, which lays out the relative nature of work test and provides guidance to not only the Workers' Comp Board in hearings, but also to the general public in Alaska as to when somebody with questionable employee status, how to determine whether they are indeed an employee under the Workers' Comp Act or not. And I just wanted to say that I believe that's a very valuable regulation and something that shouldn't be taken away, as taking it away would only provide more gray area in the Workers' Comp Act, which, from what I've been finding out and talking to the public about workers' comp for the last 6-7 years, they already believe it's one big cloud and gray area. So taking away one piece that provides a bit more clarity to folks is, again, only going to make people more nervous, create more litigation, and create more uncertainty and less efficiency in the system. And I believe that's only going to be compounded by the fact that we also, our legislation also proposed or passed in their last session, the new statute or amended the statute providing for a clear definition of independent contractor. Now this independent contractor definition is onerous to be defined as one, and so many people who in the past would have been perhaps considered an independent contractor will not be under this, as they're not going to be able to fulfill all those obligations. And those are going to be people that are going to take their issue of employee status to the board. And again, without any type of guidelines as to how we determine whether someone's an employee or not, everyone's just going to be basically putting up to a roll of the dice as to how that board panel feels on that day. They have no idea of what they're going to use to determine that employee status. And I just urge the board to reconsider their repealing of 45890 and believe that it's a very valuable regulation, something that still holds a lot of value today and moving forward. So thank you for allowing me the time to present this.
Okay, appreciate that. I'm new to this, and so I'm going to ask the board for some guidance here. is there normally just, taking comments and not really any interaction, or does the board normally have an opportunity to ask commenters questions or make, okay. Are there any, questions or follow-up comments that the board would like to make regarding the statements that, Mr. Zawadis has made? Okay.
I just have one, I could have.
And this is,
Member Shaw.
sorry.
I could have, but I didn't bring my copy of the statutes with me, and I wondered.
And just a second, if you could sort of project towards the microphone, I'm told that the, recording is not picking up the board members every time, and so just sort of turn your head towards the mic and maybe that'll help a little.
Well, my concern has been addressed in a way. I was gonna ask if we could have a copy before us, because I could have, but didn't bring my regulations with me to show what exactly it is proposed, to be repealed.
Yeah.
But that number is helping me out here, so now I have it in front of me, but I'm not sure everybody else does.
Yeah, and for everybody, it's, tab number 7, starts with the plate number, 027. All of the proposed regulations are listed.
I know, but in this case, the proposal is to repeal it. The
Oh, right.
regulation to be repealed isn't provided, so now I have it here.
Okay, good.
Okay, thank you.
Anything else? Okay, seeing, nothing, Eric, are you ready to provide some testimony on the proposed regulations?
Yeah, you know, wanted to.
Sir, please, provide your last name and spelling.
Okay, McDonald, McDonald.
Okay, go ahead.
Yeah, what I'd like to talk about today real quick, it's not necessarily the regulation, it's the controversial form. Would that be close enough?
I think it would be more appropriate if we held that until after we hear all of the comments on the proposed regulations. Is that acceptable to the board? No one's telling me that's wrong. So, Mr. McDonald, would you be willing to just hold for a few minutes and
Sure.
provide that testimony towards the end of this time period?
Absolutely, that's fine.
Okay, appreciate that. Heather, are you available?
I am, but I have a comment more for general, so I'll wait.
Okay, we'll wait for that then. Okay, moving to the, is there anyone else on the phone that would like to comment about the proposed regulations that are before the Workers' Compensation Board?
Does it have anything to do with the hearing? I just stepped in here, so I don't know what the first part was. This is Bushman.
I'm going to defer to the board in general, but my sort of general thought is that they really don't address any specific regulatory provisions related to hearing.
Or disability?
Or disability.
So do I need to wait, sir?
Yes, what's your name?
Butch McGavran.
Okay, Butch. All right. We'll call you in just a few minutes.
So if I interrupt you, it's not because I meant to, it's because I can't hear you very good. And so keep that in mind. I'm in the middle of the field with my phone turned up to 49 right now, so.
Okay, yeah, we'll make sure to call you towards the end of this time period to have some additional comments. Is there anyone else on the telephone that would like to comment about the proposed regulations before the Workers' Compensation Board? Okay, hearing none, we'll move to the room here. Heidi Palmer.
I just have a general comment.
Okay, General. Sandy Travis, do you have some comments about the regulations? Okay. Would it be possible for you to come up with just to make sure we get your comments on the record since it's being voice recorded?
Could you ask them to use their phone?
Yeah. Sure. We're getting a little bit of feedback on the telephone, and so if you're listening in with us, if you could put your phone on mute or just to try not to make any background noise, that would be helpful. Okay, Ms. Travis, are you ready?
Yeah.
Okay, so, just, state your name and spell it, and then, go ahead with your comment.
My name is Sandy Travis, SANDY-TRAVIS. I think the proposed regulations are a bad idea and not in the public interest whatsoever. And you guys are supposed to be public officials. Supposed to be. I'm sure your vote will reflect what kind of public official you are. I don't think this is in the public interest to do what is being proposed, but many, many times before you have put through bad proposals. Thank you.
Thanks for your comment.
Could I ask a question?
Oh, sure.
Ms. Travis?
Yes.
Specifically, what is it that you feel is not in the public interest? Because there are several regulations listed here, and...
Well, I'm only allowed to comment on regulations.
I know, and so specifically, which one?
Well, I can only answer that question when I comment for the general public.
And I think that's fine. If you want to make general comments, that's fine.
Regulations.
Right.
Well, then this would tie into the second part of which would...
Right, I was just meaning you could make a general comment about the regulations and being not in agreement with them rather than pointing to something specific in the regulation. It's okay.
Well, the problem is number one, the format that it was the format in which the board presented the material, and number two, how can you comment on, what I've read, you basically have to be an attorney to understand what's being proposed, and many times you have passed regulations that you don't understand, which has been made public on the public record. How am I supposed to comment on something that I don't understand? If you don't understand it either, then there's a problem.
And thank you, Ms. Travis. I think that sums up your concern perfectly. And the next person, I'm having trouble reading it exactly. It looks like Ben Williams? Bruce Williams. Do you have comments on the regulations specifically or general comments?
On the therapy.
Okay. Is that in the regulations? No. Okay, that's more of a general comment. We'll come back to you. How about Barbara Williams?
I have a comment on some of the regulations.
Okay, great. Please state your name and spell it out for the record, just so that we're tracking.
My name is Barbara Williams, B-A-R-B-A-R-A, Williams, W-I-L-L-I-A-M-S. And looking at the regulations here, I see that the division is moving forward with putting in new regulations and things, but I do see some missing things that would be really important to the first one that you have there for filings. We're imposing regulations on workers, but there's no follow-up when our documents don't get to you by facsimile, by electronic means. I've had to mail things to the division under certified mail, and I was told that you guys can't take recordings over electronic submission, and so it's really hard for us to figure out whether our information is getting to you electronically. And in some cases, I have not found out until after a hearing has been rendered that you guys didn't get my evidence, or you guys didn't get my electronic submission of somehow. But yet decisions can be made, and if you ask for reconsideration, a lot of times, those things are not addressed. Those things are not addressed. And then I saw, I can't find it, of course, because I'm looking for it. I saw some things in the rehabilitation process. In the rehabilitation process, workers have to be heard. and I mean hearing heard. Workers have been in the in the rehabilitation process, and the new regulations are nice, but if we're not addressing them with the rehabilitation specialists that they don't hear, or they have seen or unseen disabilities, those are hard to be addressed because the regulation doesn't even address any of those things. And we keep modifying and modulating that stuff, and we are forcing people to make decisions on information they don't understand, they don't clearly hear, and doesn't follow the federal guidelines for providing accommodation. And then lastly, I want to talk about the fee schedule stuff. I don't agree with what I'm seeing, the movement towards all this book-based stuff. What we're doing is we're cutting fees so much for certain kinds of providers like physical therapists and people that provide essential services for people to return to work. And if we're slashing fees for one group and not everybody belongs to the fee schedule, that's one problem, because we don't even have IMEs in that fee schedule. There's a problem there because we don't need to make physical therapy and modalities like that for workers that need that therapy to return to work successfully. And they aren't the stepchildren in our community that need to be punished because they provide a good service. And we need more community people on these review committees and in participating. None of these committees that you form have injured workers on them. There's some lovely people in this room that have past injuries, that are educated, that are very interested in what happens to injured workers, and we're not asking them or inviting them to participate in these committees, to promulgate regulations that affects us and affects these providers. We're not providing education for them. The regulations that you're providing are great on paper, but if people can't find them because you're sending them to a research system they've never seen before to figure out what parts they need, we're not serving them well. We're creating a bigger layer on the onion, and we're not addressing the issues at hand. And so I'm not for a lot of any kind of regulation changes till we look at what we have going awry now, and some of these things be addressed. Like, if people's petitions and their affidavit of readiness are ineffective or defective, workers and providers need to know what that means, and they need to know how to make it work so that they can participate in this process. You can put a ton of words in a book and call it the law, but if the people that are subject to this don't understand what it says in that book, and it's not readily accessible to them, and you don't have enough people to explain it to them, how are they going to learn? That's a big problem. And, I appreciate the time and effort that people are putting into this, but we need to be more mindful about what we're doing and include the stakeholders, because this affects injured workers. And I can't tell you how many workers I've spoken to. I've spoken to a whole new group of workers from API, and all these people are telling me that these proposed regulations may be great on paper, but the way they affect these people and the long-term outcomes that they have are really huge, and we're not considering that in our thought process. So I would appreciate it if we could think about some of those things and include it in your writing when you're thinking up these regulations and stuff, because it's really important. And people can't move on if they can't get it and they can't do their part in it, because then they feel mad or upset or they don't get their part of this. And we could do a better job in promulgating those regulations and including the workers and the providers, because they have problems that you people don't know about because you never see them, because they don't know how to join a claim, they don't know how to file a petition, and they don't know how to participate in the system other than coming to public meetings and saying, please don't cut my fees. That's not how we disseminate information to people. And I really hope that we could look at this as an opportunity to revamp and work together instead of this being so adversarial. That's a big part of, you can be adversaries, but we could be better about communicating the information so that people understand why they get what they get and why they don't get what they get, and that they have input to these regulations, because having what happens to them would really make a big impact on what you're writing and what you're putting in force for people to have to abide by. Thank you.
Thank you. And with that, I think we're done with the regulations comments, unless there's anyone else in the room here who'd like to make a comment on the proposed regulations. You, sir, go ahead.
Sure.
Come on up. State your name and spell it out for us, and then provide your comment.
Michael Budzinski, B-U-D-Z-I-N-S-K-I. I'm an attorney, a practitioner in workers' compensation for about 35 years. So I'm very familiar with the workers' compensation system. I didn't plan on saying anything today. I was just upstairs at a pre-hearing, but I don't have the regulations in front of me, but there's only one that I think is effective. The rest didn't really appear to be significant to me in terms of changes. But there's one that eliminates the right of the parties to submit SIME questions. SIMEs are second independent medical evaluations. And currently, the parties both get to submit their questions to the SIME doctors when doing their examinations. There's a regulation that would eliminate that right. And the reason that is, at this juncture, unwise is because at this point in time, there's a legal dispute as to what appropriate questions are. There's a difference between employer attorneys and employee attorneys, disagreement as to the proper application of the causation standard in 010 of the Act. And the SIME questions reflect those different views of the causation standard. It's important for the employers to submit their questions so that they know the doctors are asking questions that the employers feel are correct. If we don't get to ask those questions, we're going to get an SIME report, and we're not going to know if the doctors are answering or what their answers would be to the questions that we feel are legally correct. We have to depose the SIME physician to find out their answers to the questions we currently ask. That's a great inefficiency. The Appeals Commission itself has said that the board's SIME questions are misleading. So we currently have a legal opinion that the board's questions are not correct. At least it's headed in that direction. The issues are going to the Supreme Court very soon, and we will know within the next 6 months or so which view of the causation standard is going to be applied. But until we do, it's not correct or wise to prevent parties from submitting their own questions so that their view of the causation standard can be addressed by the SIME physician. At some point in the future, once this is resolved and it becomes clear what the legal standards are, I can see where questions from the parties would no longer be necessary. But at this juncture, because of the disagreements as to the correct questions, to eliminate the right of the employer to submit their questions would be unwise and unfair. So I recommend that part of the regulation not be adopted until there's clarity from the Alaska Supreme Court about how to apply the correct causation standard, what it means to apply that. So, any questions about that? Pretty technical, but it's what we're dealing with, and it would be a tremendous disadvantage to have that regulation go through that process.
Any questions from the board?
Mr. Budinsky, did I say that right?
Close enough, yeah.
You're talking about...
I'm
sorry, this is Chuck Collins with the board. You're specifically talking about that portion of 092 submitting, because I think it currently says submitting, what are they called, interrogatories, and we were going to strike that and put in written questions.
How I read it, and back when I did read it, was that and I don't have the regulation in front of me, the proposed one. I read it as striking out the right of the parties to submit questions, that only the board's questions would be submitted.
I think it's right there.
So,
I think it's right there, that's what you're discussing.
right, the board designee, the pre-hearing officer, shall identify the disputes, prepare and submit questions. It says the board may direct.
So,
Someone.
It's state stamp 10, the previous date.
36.
State stamp 3536 is where.
So I think that the way I read it was that the parties would not submit questions, neither the employees nor the employers. Only the board would, because the board has a standard SIME letter. I can tell you the SIME letter is defective legally. I think the Appeals Commission is correct in that regard, but that's the current state of it, is there's an opinion that the letter is incorrect. So you don't want to institutionalize that while there's this dispute about the correctness of the letter. You want to wait until that's resolved, and then you can decide, are you going to eliminate the right of the parties to weigh in on something because the board letter is correct. There may be a time when it's acknowledged to be correct. We're not at that time right now.
Mr. Chairman?
Yes.
If I could comment. We had quite a long discussion, as I remember, about this issue in October. And one of the things, this is Member Murphy, one of the things that we discussed was the fact that if you have the employee and the employer submitting questions, sometimes the way you present a question predetermines the answer you're going to get. And so the SIME physician may get two questions that are asked in totally different ways, but they are about the same subject, and it can get confusing. We had no intention of saying that that form letter, that the board form letter would be the only questions going forward. What we said was that the hearing officer would take into account the dispute between employer and employee, or disputes if there was more than one, and would develop questions that would assist the board in making a decision after getting the report from the SIME. And we felt that that was a much more fair process than having each side submit their own questions. That is how I remember it. I mean, if you remember it differently.
Well, just a point of clarification, this is Gray Mitchell. So I don't see anything in the proposal that would prohibit either of the representatives, whether they're for the employer or for the injured worker, from submitting questions to the SIME provider.
We eliminate, that was one of the sections that we wanted to eliminate from regulation. Is that, you were there, Chuck. Is
But
that
still, the proposed regulation does not say specifically that an attorney representing an injured worker is prohibited from asking questions to an SIME provider.
No, they could depose the provider, but not provide questions to the SIME physician prior to the exam.
Maybe I can clarify a little bit. Under the current process, when this is Ron Ring, and under the current process, when we start an SIME, and the records and everything go to the SIME doctor, the board will send a letter with some standard questions in it. And at the present time, if the parties are represented, they can submit questions, and those are sent to the board, or to the SIME doctor as well.
In addition to the board.
In addition to the board's question.
Yeah.
And what it looks like to me the proposed regulation is doing is disallowing the parties' questions. However, another section of the regulations allows both parties to submit written questions or do a deposition after the SIME doctor's report has been received.
Yeah, that's
so questions can show up in two places.
Yeah, that's also late in the process. You want the doctor to get the correct questions because the letters and the questions convey information about the legal standards. The questions themselves convey that information. If the doctor gets incorrect information about the legal standard from the board's letter, which it does, it really sets things off in the wrong direction all from the get-go. So you need to ask questions right away when the doctor is considering all of the issues so that they get perspectives of both sides immediately. If you wait until after they've formed an opinion, then you go in and say, well, forget that earlier question, let's answer this other question. Number one, you've got to do the deposition, which is a huge expense. And number two, the doctor's already down the road mentally on a perspective, they may not be legally correct. And so you need to ask questions at the get-go, which to be fair to everybody. If the board's questions were correct, that would not be a problem. There's a great big dispute right now, but that's whether they are correct.
But we are not talking about that letter. We're talking, or that letter with the questions.
Member Murphy.
I'm sorry, shouldn't have butted in. Our intent was that the hearing officer would develop questions based on the issues that had been raised by both the employer and the employee. And we felt that that would just be a more fair process.
The problem with that is that the hearing officers reflect the view of the board as what questions are. That does not comport with what the employer views to be the employer view of the correct questions. That's where the dispute is currently, just before the Supreme Court, as to what the correct question is. At least the issue is.
Why don't we let the Supreme Court answer that? We can move on to public stuff that I need to hear.
Sir, just a point of order. Please wait until you're addressed by the chair.
You guys are boring me to death, man.
I understand. The meeting is a public meeting, but we are still, to be respectful of other speakers, and so.
I was trying to be sure.
Okay. Well, please wait until you're addressed by the board chair, and then you'll have plenty of opportunity to make comments. Anything else?
No. I would make, this is Ron Ringley, and I would make at least one of the cases that's at the Supreme Court now that dealt with the issue of the questions was not the standard board questions. There were some additional questions that had been asked. And so I'm not sure that it holds across the board that the commission has objected to the general question.
It's just the mere fact that there's a dispute now makes it unwise to do this. That's what I'm saying. The fact that there's disagreement, good faith disagreement, as to what the question should be, means don't now institutionalize a letter or a format that adopts one side over the other. Wait until it's been resolved and then reconsider it. Next year, that may be a fine regulation because everyone will now be in agreement as to what the law, what the SIME questions therefore should be. But at this moment in time, there's great disagreement about it in good faith, about what those questions should be. So don't institutionalize the questions until you've sorted that out. It would be unwise, in my view.
Appreciate the
All right,
comment.
thank you.
Is there anyone else in the room that would like to make public comments on the proposed regulations before the Workers' Compensation Board? Is there anyone on the phone who would like to make comments about the proposed regulations?
Yes, my name is Ward Wells.
Could you spell your last name, please? Actually, spell your full name. I didn't catch the first part.
Ward. My first name is Ward, W-A-R-D. My last name is Wells, W-E-L-L-S.
Okay, go ahead with your testimony, your comments.
Approximately 30 years ago, I was severely head injured. During that time, it was a workman's comp injury from up on the North Slope. I really felt like my rights as a human being were placed aside in order to support the ideology of the workman's comp organization. I lost everything that I owned.
Mr. Wells?
Yes?
Mr. Wells? Sorry to interrupt you. It's possible that maybe you didn't hear the earlier announcements, but we have a specific time period set aside for comments on the proposed regulations. And so
Okay.
if your comments are more of a general nature for the board, you know, perhaps.
I apologize.
wait.
I dialed in late, and I apologize for that. I
That's
want to
no
be
problem.
more specific. I do feel like the way that the Workman's Comp Board and the laws that it works under are poorly organized in regards to the rights of human beings, just generally, and that's specifically to the state of Alaska.
Okay, Mr. Wells?
And my specific complaints.
Mr. Wells?
Yes, go ahead. Yes.
I just want to make sure, I think that we don't have anyone else besides you to testify about the proposed regulations, but I want to make sure, is there anyone on the phone that would like to comment about the proposed regulations that are before the Workers' Compensation Board?
Yeah, Butch McGavin, MCG, AV, RAN.
Mr. McGavin, do you have comments specific to the proposed regulations, or are you?
No, yes I do. It's the one we were just talking about. Why do we throw a fit about it? Them being able to put a forms in. It's your guys' responsibility to give that information. I didn't have any choice. Okay, let me say. I don't know any worker that had any choice about talking to their IMs when they were sent to them.
Mr.
Why would you do that choice? Yes.
I'm just trying to make sure that we're covering the issue that we need to be covering at this particular time. And so I wanted to make sure that you were aware that we're taking comments right now on the proposed regulations and the proposed regulations only. And so if there is some item, some issue, some point within the proposed regulations that you want to make, then you're free to make that. But if you want to talk more in a general sense about issues with workers' compensation, then we just need you to hold for just a few minutes. We're getting close, but we just want to make sure that we close out the public comment period for the regulations first. So do you have any comments related to the proposed regulations specifically?
I guess put it that way, no, because the one that should be on there is not on there, which is helping the disabled. So I'll talk to you in a minute, I guess.
Okay, good. Thank you. Is there anyone else on the phone that would like to comment about the proposed regulations?
Would that include in regards to the questions? Is that referring to?
Well, I'm talking specifically about the proposed regulations that are before the Workers' Compensation Board. There's a set of them that have been put out for public comment. We've had a written public comment period, and now we're taking an oral comments during this 1 hour period with the board. Then, once we are done with that public comment period, then we'll have a general public comment period to talk about every other regulation or every other issue that might be worthy for consideration of the Workers' Compensation Board. But right now, we're focused on just those specific regulations that are being proposed to be changed. So is there anyone who has a comment on the phone about that particular proposed regulation package?
Well, this is Heather Johnson, and I'd like to follow up on the gentleman's comment about the SIMEs.
Okay.
The SIME process is already not fair for the employee, and so if you take away the ability to ask questions from the get-go, you're actually kind of messing with due process. We can't really rely on board members to always have fair hearings and fair decisions. Right now, I know someone getting ready to go to an SIME where the EME was given 8.8 centimeters of records from a 5-week hospital stay. And we've been trying to get the record corrected because the EME actually said that he broke his neck and he had a failed fusion surgery when that was not the case. You know, there's just glaring problems in the EME report, and we haven't been able to have a hearing to look at, you know, the glaring problems in the EME reports, and then they're going to be sent to the SIME tainted as it is. And so if workers can't ask questions from the get-go, like the gentleman said earlier, when the doctor goes to make their report, if you have to depose them months later, they don't remember. And so I think it is very unfair for the worker. And other than that, I've just got general comments.
Okay, I appreciate that comment.
I want to know how nurses look back. Look at that face.
For those of you on the phone, please mute your phone while you're not providing comment. It does provide a disruption, and it makes it difficult for other speakers who are making comments. So please be respectful. Is there anyone else on the phone that would like to make a comment regarding the proposed regulations that are before the Workers' Compensation Board?
I want to know how come that lady said the exact same thing I did and you didn't want to talk to me.
Sir, is this Mr. McGavran?
Yes, sir, it is.
Yes, Mr. McGavran, the previous speaker, Ms. Johnson, did speak specifically to a proposed regulation. And then she did indicate that she wants to make general comments also, and so she will be offered an opportunity to do that, as will you. But we're just trying to make sure that we follow, a set procedure and that we allow the comment period on the regulations to be met, because there is a legal requirement that we're meeting here to provide the public with adequate opportunity to comment on the proposed regulations. There's a different standard and requirement for us to provide the public with an opportunity to make general comments, and we will meet that also. But right now, it's just for the proposed regulations. So is there anyone else on the phone who would like to make a comment regarding the proposed regulations that are before the Workers' Compensation Board?
All right, let me put these people on mute. I'm trying to do something with the Workers' Comp Board. Come on, damn it.
Okay, hearing nothing in terms of a request about the regulations, we're going to close the public comment period unless someone calls in and we hear a bleep or enters the room in the next 15 minutes, and then we will pause the general public comment period and allow the individual to make a comment on the regulations, because we do have a specific time period set aside for that.
Hello.
Remember, we're operating with a full room here. There are several people who want to make public comments, and so we will limit the public comment period to 2 minutes. I did realize that I had overlooked a person here in the room who had indicated an interest in making a comment on the proposed regulations. So we'll move to that right now. Sandy, Travis, if you'd like to make a comment related specifically to the regulations, the proposed regulations, then please do so.
After listening to speakers, another problem with the SME and the proposed regulation is that SIME doctors, the same SIME doctors, have been on the list for years. They are making a living off the Workers' Comp Board, the employers, and the insurers. When you go to an SIME, yes, they send a defective letter, and the employer and the designee does get to contact and talk with the doctor. But what I'm saying is, when you have SIMEs who have been on the list for years, they're basically bought and paid for.
Thank you. Okay, now, what I'd like to do is take a 5-minute recess, and then we will pick up with Mr. Wells, who had started his general public comments, and then we'll move directly to you, Mr. McGavern, after that. But a 5-minute break. We'll see you back on the record. I'm looking at my official iPhone time at 11:10, 10 minutes after 11. We're going to go off the record now.
Okay, hey, I'm gonna have Barbara call me back when you guys come in the office. I got things to be doing. Okay?
Okay.
Okay.
Barbara?
Hey, Barbara, he's trying to talk to you.
Yes, sir?
This is Ward Wells.
Yes, sir?
Can you contact me?
Yes, sir, I will.
232-5221.
Okay, sir, I'll send you a message.
Thank you.
Yeah, I do. I don't know. And what was that? Did I say it? I remember it. I was gonna,
Bring him up on charge.
but I remembered. Susan talked to us too about it coming from the board, questions coming from the board. And the questions are worded differently, and they're not accurate. And so looking at the board documents, and then it's the last one, right? And I remember them saying that you could ask the question, the way you ask the question determines the answer you're going to get. And it's the board's medical examination to some people, that's right.
They're not really right to believe.
Exactly, medical. And I could see why you're only allowed to do that if you can't call a question. Isn't it written? Is that right? I think it's written only if you're. No, only results.
Meeting minutes.
And, oh, that's it. So I'm unrepresented party can't have my questions. I didn't remember that.
I thought so, but.
6 to 11? Oh, okay. I think it's 5 A and B is our problem now.
We only get 6 months.
5? No, that's a question. Are you an 092?
Yeah.
Mine says,
general submission,
oh, it's H5?
Per medical issue. Oh, if all parties are represented by counsel, the board should submit to the decision all questions submitted. Only question is not only question about how the board needs to be submitted.
So they can submit them,
Yeah.
but they're reviewed versus the attorney submit them, they're automatically regardless of somebody else.
Yeah.
Whether the designee agrees or not with the question.
And it's
supposed to be, the report is supposed to be made so that we can make a better decision, so that we have an independent person not hired by the employee or the employer.
Is there a leader on the telephone?
Talking about quite a bit about the questions she's getting, she's going to get something out of it. And then she's probably basically with them, she's and asking,
Okay, 1 minute warning.
Ding, ding, ding. Or it could be, it's telling you when you're gonna be interviewed by the.
I'll find out.
Okay, we are back on the record, 11:10, and we're ready for the general public comment period, although we still just have a few minutes on the clock. I don't believe anyone has entered the room, but I want to make sure that there's no one on the phone who's joined us just at the last minute here to make a comment on the proposed regulations that are before the Workers' Compensation Board.
This is McKenna with Adjustment. I was on the line.
Oh, you were on the line, okay. All right, I believe we're ready to move on to the general public comment period. And Mr. Wells, you had started making some public comments, and then we had to move along to Ms. Travis. And so I wanted to give you the opportunity to continue if you have any additional general public comments for the board. And we are going to have to impose a little bit more strict timeline, so you have 2 minutes, sir. Go ahead. Mr. Wells?
I'm telling him as fast as I can that it's his turn.
Oh, okay. Yeah, that's kind of irritating, that thing beeps. Sorry.
We're in a park.
I know, I apologize. I don't know how to work this timer. Sometimes I don't know how to reset it.
Okay.
Got it?
Yeah.
What do I have to do, just hold it? Yeah. Okay, Mr. Wells, are you available?
I just texted him.
Okay, we'll come back to Mr. Wells. Mr. McGavran, are you available to provide your testimony?
I texted him too.
Okay.
I think he said you were gonna speak and he was leaving because he was busy.
Okay.
I thought that's what he said. I think that was him, one of those.
Okay, we'll move along then to Tana Noe. Did you have general comments for the board?
Well, one is about your question part. In my experience with the SIME doctor, they seem to go over the same questions every time that you go in there, which wastes a lot of time, and you feel like you're not being heard more, like in my condition. Anyway, the other thing is that on your website, your technical information is not really user friendly, and even with an attorney, it's hard to understand the information process and making decisions on what I should do in my case. And then the doctor have their fees included in this fee schedule, so that there is no incentive to buy opinions that outweigh our doctor's opinions. If all physicians were to be paid the same, it would make the process fair for everyone. For instance, I'm receiving my bills currently because my doctors have not been paid. We need to process the workers' compensation that really recognizes injured workers' disabilities as well as provide better accommodation. Some people have unseen disabilities, such as me. I'm not a good public speaker, and I get really nervous in explaining my views of things. And I feel like that I'm being put on in front of a judge, if you will, and like people look at my records and they look at the past instead of my current situation. That's not fair to a person such as me, as well as the others that are trying to go and make their case with you all. And I was injured that day, and I'm still dealing with my injury. Anyway, aside from that, I would appreciate you guys just, understand people as a human. We, are willing to work and would like the Workmen's Compensation Board to work with us.
Okay, thank you, Ms. Noe. That was a helpful testimony. And just one point I wanted to make, that, this is not your only opportunity to provide input to the board, is making these public comments. There are other opportunities to submit letters. You can send a letter to me. You can send me an email. If you've got issues that related to the website or other things that you, have concerns about, this shouldn't be your only chance. And so I just wanted to let you know that and let the other commenters know that, you don't have to fit everything into 2 minutes here. But we do have a time limitation for this particular meeting. Yes, and so, we are kind of trying to keep things moving along fairly quickly. So please don't get upset if I cut you off when we reach that 2-minute timeline. It's not my intent to stop you from providing input to the board. Certainly, anytime you have an issue, please bring it up and we'll add it to the next meeting docket. It's not like we're not here to listen to people. It's just we do have a limited time for this particular meeting.
Right.
So. Next on the list, and by the way, Ms. Noe, you did an excellent job for someone who's not a good public speaker. You did fine. So Brian Zamatis, are you still on the telephone? Right. Eric McDonald? Okay. Heather Johnson?
I'm here.
I'm so sorry. I had it on mute. I apologize.
Oh, no, that's great. Is this Eric McDonald?
This is Eric McDonald. Sorry about that. I was talking in.
Yeah, go ahead with your comments. You have 2 minutes.
Okay. I did notice that the proposed regulation, there was a change to the form 155. What I'd like to talk about is the form itself, the controversion form. I'm an injured worker, and throughout the course of the history of my workers' compensation claim, I've had a lot of opportunity to speak with billers, and there's a lot of general consensus between all of them about the controversion form. And I have a few points here. I'll try to talk as fast as I can that I think that would help help everybody. Number one, the state of Alaska. The name State of Alaska on the front of the form, it confuses providers and billers' offices because they think that it's the state of Alaska that sent the form. And so they automatically, every time I've talked to them, they'll say, well, the state of Alaska has, sent this. And they believe that it's an actual final denial when it's actually not. And another thing I'd like to talk about is is where it says full controversion. All it lists is controversion on the front, and it confuses providers into thinking that it means it's a full controversion. And by placing the partial controversion on the page behind it, it doesn't give any context. So people seem to automatically think that it's a full controversion. And it's very confusing. And also the certificate of service, when you place it on the front next to to where it says all benefits controverted, it also gives the appearance of kind of like finality, and they don't go past it because it says certificate of service. And then on the back where it has the signature of who actually produced the controversion, it's very confusing.
McDonald, just if you could wrap up here in the next 15 seconds.
Okay, I got the attorney's signature. It should identify that it's the insurance company, and it should be placed on the front. It should be where the state of Alaska is. Stop confusion.
Okay, thank you. And I'd encourage you to...
This is Mr. Wells. I'm sorry I dialed in late.
Okay, we'll come back to you. Mr. McDonald, I just was thinking it could be helpful if you wanted to put those recommendations in writing, if you have that opportunity. It might help to kind of focus the points that you're making. It's a little bit difficult since we don't have the controversion form in front of us to even really see what you're talking about. So if you could submit those in writing, it probably would be helpful. All right, Mr. Wells, you started your testimony earlier. We're still going to give you 2 minutes now. Go ahead with your comments.
Thank you very much. So, unfortunately, I just got out of the hospital yesterday, but I felt very driven to be a part of this conference, a part of this hearing, in that my entire life has been changed multiple times by the Workers' Comp Board, and I've ended up losing everything that I owned and starting my life over. I find it largely due to the regulations and lack of ability for the Workers' Comp organization as a whole, and specifically by rules and regulations, to work with the members of the community of the state of Alaska, with the residents of the state of Alaska. I find the majority of the regulations were specifically designed in legalese for lawmakers. And in my case, I was unable to function. I had a severe head injury, and I was not able to, I needed representation, and my representation was at best poor. My ability to represent myself was poor. Later, I was helped by individuals that volunteered and found that many of my human rights were being violated. I found that
Mr. Wells?
The work comp
Mr.
program
Wells?
as a whole was
Mr.
lacking
Wells?
in
Mr. Wells?
ability. Yes, go ahead.
If you could wrap up in about 15 seconds, we'd appreciate it.
Okay, I would love to be a part of this in the future. Unfortunately, I'm not prepared today with specifics, and I apologize for that, but I want you to put my name in as someone that is an advocate for the people of the state of Alaska. And I'm also a former state employee, and I was able to rehab outside of the work comp program to a very high level, but it was only because of my persistence. There was zero support from the workers' comp board for my success in life. I find that reprehensible. Thank you.
Yes, I appreciate your comments, and I'm sorry that we don't have more time to listen to the issues, but certainly you're welcome to put your concerns and issues in writing, and you know, you can send them to me, and I will review them and see if there's something that we can work with you on. Next on the list.
I will be happy to do that in the future. Thank you. Good enough.
Okay. Next on the list, I'm thinking, is Butch McGavran back on the phone?
Yes, I am, sir.
Okay, go ahead. You've got 2 minutes, and then I'll give you an extra 15 seconds at the end. But try to keep your comments organized.
Okay.
Thank you. 2 minutes.
I will. Speaking as Butch, I went through this process. I'm telling you, it's hard. Every person I've talked to has the same issues. There is nothing in place to help the disabled. I cannot hear with a crap. I hear 9 letters out of the alphabet. You think I understood anything going on? On top of that, I'm dyslexic. And none of that has ever been addressed. This is the second time the guys' board meeting. Last time, they wouldn't let me talk. So, I don't know how people even can claim you're for the people. I don't understand it. Your website is not up to code. Your offices are not up to code. You have nothing for the hearing impaired whatsoever. And I don't see anything on the list. I've tried to bring it up 3 times. So I don't know what we're going to do about that. What are we going to do? Make us workers wait another 5 years for you to get it? We've been waiting since 1964 already.
Okay, Mr. McGavran, thank you for your comments.
Okay. You don't have anything to say about that? Where is your hearing devices? Where is your ability to help the disabled?
Well, Mr. McGavran, we really have a limited time for comment.
A limited question. Answer it.
To answer it would take longer than we have set aside for this meeting, and so we're not really set up to handle that kind of exchange right now. I can tell you that when accommodations are requested for an individual with a hearing disability,
I'm calling you right now. I've never had my accommodations met. Never.
Okay. I appreciate your comments, Mr. McGavran. You know, I'd offer that, you know, this is not your only opportunity to present any issues that you might have.
Multiple times. Matter of fact, you're soon to be under federal investigation. So how many times do I have to do it?
Mr. McGavran, I appreciate the comments, and hopefully that we can count on you to be respectful to the rest.
Out the door like you did with the fucking program.
Mr. McGavran.
3 times you do the same fucking thing.
Mr. McGavran, please be respectful of the process and of the other Alaskans who are participating in this.
And I'm speaking for shitloads of them. Everyone I talk to has the same problems I have. Every single one of them is the same.
Mr. McGavran, we need you to stop commenting at this time. You're not allowed to use that kind of language in public meetings like this, and you need to follow Mr. McGavran.
Just hang the phone up then. That's the only way you're going to get me to stop.
you're on a call with several other Alaskans who are trying to get their, they're trying to get their opportunity to make comments also. And so by doing what you're doing, you're actually hurting their opportunity to make comments. So please, sir,
I bet you the
please.
comments are close to mine. You're gonna run the circle, but yeah, I'll be quiet. I'll hear what they gotta say, because I'm telling you right now, you're a liar.
I understand your frustration, sir. I'm Samantha Atlas.
Okay, is there someone else on the phone that would like to provide comments, general comments to the...
Yes, I would. My name is Samantha Atlas. I would like
I'm
to
sorry,
speak.
Samantha, Heather Johnson was signed up just before you, and so we'll take her comments first. Go ahead, Heather.
Okay, thank you very much. I just wanted, kind of speak from the heart today. I want to tell you, I've never really been injured on the job, but I've kind of seen the fallout of what people go through after being injured. And it's not just affecting the people, but it's affecting their families. And it's time that you guys even the playing field so the injured workers can get equal access and protection under the law. People who suffer catastrophic injuries have been unable to obtain discovery, while insurance companies and their attorneys get extensive discovery, many times about things that have nothing to do with the body parts injured. And I've watched while they employ every dirty, underhanded tactic to ruin people's lives. Injured workers are powerless to stop the full onslaught against their character, reputations, relationships with their doctors, and their persons. Alaska has allowed what is supposed to be a no-fault system to become an adversarial system. People with disabilities are not only dealing with sometimes very life-changing injuries, but they are having to learn litigation to keep from being buried. I've heard hearing officers state that they don't have to follow the law, that they can make it up as they go. They seem to cater to defense attorneys while workers are subject to having to go through years of unnecessary litigation for obvious injuries. Hearing officers do not include employees' issues on pre-hearing summaries and will not correct them when asked. Workers are being sent out of state to doctors who are willing to have their opinion bought for the right price. These reports contain obvious fraud, yet people can't complain to the state where the examination occurs because it's an Alaska case. Nor can they complain in Alaska because the exams did not happen in the state. These doctors need to be held to the same fee schedule that employees' doctors are held to. Controversion notices need to be changed. For years, I've tried to explain to office staff that the controversion does not come from the state of Alaska, yet they always argue with me and fail to understand that it is the defense. Studies show that the stress of litigation itself can cause or exacerbate PTSD, and people are being maimed just by being in litigation alone.
Heather?
So, yes.
Just 15 seconds, please, if you could wrap up.
You just need to give workers a chance to correct their medical records and to post EME doctors before an SIME is ordered. The SIME is a one chance to prove a case, and if you're not allowing correct evidence to go to SIMEs, then the worker is never going to get justice. And I'll put the rest in an email.
Thank you. Samantha Johnson. What?
Samantha Atlas.
Oh.
Samantha Atlas.
Oh, I'm sorry. Samantha, if you could spell your last name for us, please.
Atlas, like the world, the map, ATLAS.
Okay. Go ahead with your comments. You have 2 minutes.
2 minutes. I agree with the guy that was talking earlier, and I agree with this lady, Heather. There's a lot of things that are out there, and, as an injured worker, it's just like we get shunned. We get put to the side. And when you try to tell somebody what's going on, nobody has time for you. And right now, as I'm talking to you, I'm not in Anchorage. I'm in Washington for treatment, and I thought I was going for treatment for my PTSD. I feel like I'm here on a gym membership because I spend 4 of my hours back to back between one type of physical therapy to occupation therapy. And, there's other things like this that I'm not the only one people are going through, and people need to start hearing it. It's not somebody telling a story being somatic It's that somebody telling a story because they're lacking attention. Somebody needs help. And there's not many people out there that are willing to help, especially when you find out, like somebody like me as an example, and many other of my colleagues. Where do you work? Telling me you work for the state. Oh, good luck with that. Talk to your people in workers' comp. Try to, but a lot of times you tell them the sky is blue. Later on, unbeknownst to you, as an example, I'm just saying as an example, without going in deep with my case, you know, they'll tell you that the sky is purple. And it was just like, you know, we're lacking help in things that are going on with us. We need help with medical treatments, getting the right treatments provided to us, getting what we need to take care of us so we can function better. Individuals get on with our livelihoods in life the best way that we can before we got injured at work. Messing up a home life, yeah, that's time frame that'll never come back. You know, we need help. Start listening to the people who got hurt. People that are doing these IMEs, you know, I don't know how they can sit there and label you as being somebody who's being deviant. Never met these people before.
Ms. Atlas?
Yes.
Could you wrap
Is the
up in
time
about
up?
15? Yeah, you got 15 seconds to wrap up.
Okay, please start listening to the people. When people are trying to get help, nobody knows where to get help from because it's like people in Alaska, it's just like they're all against people who get hurt. It's just like, let's double dip and see who we can collect some money from. And while people are suffering and not knowing what to do, how to carry on, where to get appropriate treatment that they actually need for what's going on.
Appreciate your comments, Ms. Atlas. And again, the record does not close just because, you know, your 2 minutes is up. You certainly have the opportunity to send us a written list of issues, and we'll definitely consider those. Is there anyone else on the phone who would like to provide general public comment to the Workers' Compensation Board?
This is McKenna with Wilton.
Okay, could you please spell your name?
Sure. McKenna. Last name is Wentworth, Wentworth.
Okay, and go ahead and we'll give you 2 minutes with a little bit extra on the end for a closing.
Okay. I wanted to just open with the commentary on the regulations I felt were a continuation of possible statutory changes that were brought up with Senate Bill 79. They ultimately failed at the legislature because there were a lot of objections. Those particularly with having to do with the ARH status, SIME providers, and the EDI filing, and the employee status. Those were deferred to the Workers' Comp Committee. I feel like some of these regulations might be a little bit premature and haven't really considered the outcome of that process, so I'd recommend that some of them get put in abeyance for the immediate purpose. With respect to determining employee status, I feel like that does not need to be removed from the regulation. I think there's an assumption that you could defer strictly to the statute, but determining employee status gives the board the leeway to determine a very fact-specific scenario. With regard to the ARH, I want to just put on the record that I think it's, in my experience previously as a pre-hearing officer, it actually hurts the employees more than anything when you rush the process before people are actually ready for it. I feel like in the regulation right now, ultimately, due process is what will hold up in the courts, so I'm worried that this won't withstand.
How's it going?
So I would recommend that you, instead of allowing some sort of impromptu ARH or impromptu hearing at a pre-hearing office, allow at least some kind of
hearing.
Can you hear okay?
I'm in town, so I'll talk to you as soon as I get off.
With respect to SIMEs, I'd like to see, or we're advocating for some Alaska-specific training for the SIMEs. We find that we go back to them quite often because they're not familiar with the Alaska law. So the overall cost of it is really prohibitive. On a nice note, I'd also recommend that you add a daily wage per diem to the employees when they have to travel out of state, because it does take them out of work for several days at a time and they're not compensated for that. And with regard to the SHROI, I'd recommend that you not codify anything right now. When the SHROI data, which include the initiation, termination, payment of compensation, or denials, the information that is currently being published by the Workers' Comp Board is not sufficient to the employees, and we're getting a lot of phone calls with, hey, my claim was denied. Well, really, it wasn't denied. It was just this piece. So that goes to
Ms.
people earlier.
Ms. Wentworth?
So I go ahead. I'm done.
Oh, you're done? I was just going to give you 15 seconds to close it off, but if you're ready to conclude, that's fine too, or you can have 15 seconds.
No, we're good. We're good. Thanks.
Okay. Thank you. Is there anyone else on the telephone that would like to make a comment? Okay, hearing none, we'll move to the room here in Juneau, or in Anchorage. Forgot where I was for a moment. Barbara Williams, do you want to go?
I'm going to read it really fast, and I have a copy for you.
Can you ask them to mute?
Yes, we are getting a little bit of feedback on the telephone, and so, again, if you could mute your phone, put it in silent mode so that we don't hear your side of the conversation, that would be greatly appreciated. Go ahead.
Okay,
You got the same 2 minutes with a little extra, but not too much.
I've got it written down for this section, so thanks. One, injured workers need better information to work with and better access to legal assistance. Injured workers need their defenses adequately noted in pre-hearing and hearing summaries. These really need to be recorded for integrity and adequate record of the proceedings. IME fees should be all fees for service should be included in the fee schedule, so IME should be in there too. Injured workers need discovery to prove their cases. They're not getting adequate discovery. Injured workers deserve respect and civility when dealing with claims. We need referrals for investigation for the Division of Insurance. There have been no referrals in the past 11 years, according to the Alaska Division of Insurance. This needs to change. Referrals need to be made by the division and, more importantly, followed up on by the division. More transparent information about those referrals, as well as results, should be somewhere the public can access. Injured workers should not be shamed or disparaged for asking for accommodations if they're disabled. If the staff needs training to deliver those services, as well as learn what the law requires the agency to do. Workers and providers need more information in general geared towards them to better participate in the workers' comp process. The Workers' Comp Division website is not ADA compliant and lacks lots of valuable information. Injured workers need to process their claims, understand benefits, and utilize board forms. The new compensation reports are impossible for injured workers to read and understand. The letters that go out with those are confusing and do not provide user-friendly information or clear information that workers can relate for benefits paid or deficiencies that may be occurring. And workers have less than ever before access to their files. When workers ask for their files, they get a runaround, not access to their file. I can show a number of examples how workers or other parties have tried to gain access to their files for information to prepare for important events. They are generally discouraged and generally contain hundreds of duplicate documents. Finally, we need an audit of the workers' compensation system again. The last audit revealed many problems with the division, and some of the deficiencies have never been addressed and seem to keep festering with age. Thank you for this opportunity to speak to you today and speak on these important topics. And also, I gave each one of you an ADA flyer so that you have notice that the ADA applies to you and where to find the regulations. Please take note of that, and please educate yourself. It's really important for workers. Thank you.
Thank you for your comment. Is there anyone else in the room here? I have Sandy Travis. Would you like to make comments? Yes. Okay. And again, try to keep your comments at 2 minutes.
My name is Sandy Travis, F-A-N-D-Y-T-R-A-V-I-S. You were given notice, you've heard on the phone what your responsibilities are. You can be held, will be held responsible in federal court. You have to follow the laws, state and federal. That's the law. I have ran into this, the interpretation of the medical fee schedule for the providers that I've ran into. There's actually seven of them that I'm dealing with right now. Their interpretation is that you bill Medicare for workers' compensation. They've committed a Medicare fraud, put fraudulent medical things on my medical documents, and have basically refused to when they send in a form for workers' comp that wasn't even right. Now, these people are affiliated with you, board. They are committing many levels of fraud, which they will be held accountable for, and their businesses also, which will all come back to you, the board. I'm not, the problem is nobody, a lot of these providers who are claiming to take workers' compensation are not following the last fee schedule. The insurers are not following the last fee schedule. The insurers are not following the conversion forms. If nobody's following the rules, I don't understand the need to change when they don't even follow the current rules that are in place. Thank you.
If you need a few extra seconds to wrap up, go ahead, 15 seconds.
Well, you might take into consideration that each and every person can file against you and is held accountable. So I heard there's quite a few of them on the phone, and there's me that you violated my right of way just in this meeting now. So you multiply that, we'll just say 5 people, that's 5 lawsuits each against the board and the division. So I suggest you strongly read what Barbara Williams gave you and have a full understanding of what you read and what regulations you are passing. And just remember you are a public official.
Thanks, Ms. Travis. Okay, Heidi Palmer?
Yeah, I do have a more detailed list in writing for you. Yeah, I won't have next time.
Could you ask him to mute again?
Yeah. For those of you on the phone, we're getting some background noise. Sounds like shuffling of materials or something. So if you could either mute your phone or stop making the noise in the background, that would be very happening right now. Okay. Just for those of you on the phone, please take into account we are recording the meeting, and if you're doing something in the background, you're making it difficult for us to record the proceedings because all of those sounds will show up, and it's difficult then to provide a good record for what was discussed. So please either mute your phone or try to keep quiet in the background. And Ms. Palmer, the floor is yours. You have 2 minutes with a little extra on the end.
Okay, so I am Heidi Palmer, and I'm here on behalf of Denali Physical Therapy and Health. A couple things we wanted to address. First, our opposition to the 15% reduction of MAR for physical therapists. Physical therapy is as good, if not better, than surgical or pharmaceutical interventions and comes with a significantly reduced cost. These typically play a critical role in preventing surgery, reducing opiate use, and getting injured workers back, which should be everyone's primary goal. We also want to express our opposition to the application of NPPR reductions to physical medicine services. we have 6 physical therapy clinics between Anchorage and the Mat-Su Valley, which range from 15% to 80% patient volume of compensation patients. 2 problems that we're having specifically are with the work hardening program as well as functional capacity evaluation. Work hardening is a specialized program designed to prepare injured workers for rejoining the workforce over the course of 6 weeks. The program takes anywhere from 1 to 8 hours a day and is filled out in units. The first unit is 2 hours, and then each additional after that is its own unit. CMS has put limits on each additional unit to 2, which has completely destroyed our fee schedule and our reimbursement for that program. Functional capacity evaluations are an integral part of reintegrating injured workers back into the workplace and measure the worker's ability to perform necessary job duties and determine whether or not it is safe for the workers to perform the required tasks in their position.
I'm sorry to interrupt.
CMS has also implemented unit limits for date of service to 8. The customary amount of units billed for a properly performed FTE is 16. So we are taking substantial write-offs, tens of thousands of dollars over the last couple of years. In conclusion, we are proposing a carve-out for the work hardening and functional capacity evaluation CPC code as exclusion from all CMS coding edits for number of units, and a compromise on the 15% reduction from our physical therapist, and request you consider reimbursement for licensed PTs at 100% and 85% for PTAs, massage therapists, or other professionals operating under the license of.
Okay, appreciate your comment.
Thank you.
Is there anyone else in the room?
I have a quick question.
Oh, yeah, go ahead, I'm sorry.
So have
I'm sorry to
you given
interrupt.
this to the MSRC?
We have not.
Okay.
Not yet, no, we just took it.
Okay. They're kind of, they advise us.
Okay.
Yeah.
Yeah, we just actually learned about them, so that's
Okay.
our next step.
Good.
Thank you.
Good.
Thanks for that clarification, Mr. Austin, Member Austin. So I have one other person, Bruce Williams.
Can move slow.
Here, take your time.
Don't get injured.
Oh, no. I bounce.
Okay, same thing, Mr. Williams, if you limit your comments to 2 minutes, we're coming up against, you're standing in between lunch. No pressure, but 2 minutes and a little bit more. Go
I
ahead.
like what that lady said. She said it's basketball, college. And because I know I got hurt in '92, you guys, and I've been struggling with it since. And I've been going to physical therapy and all that over the years. And those people work really hard. I was in a wheelchair for 5 years. And I can walk now because of them. And I've had cancer 3 times since then. And I had a bone marrow transplant when I was 15. And that's what saved me, was physical therapy. And the doctors and the nurses. You guys gotta listen to them. And I heard a lot of people talk, and you didn't have much time to listen to them, and I understand. Because what you guys are doing is a good job. And you're trying to do the best job you can, but you can do better. Really, you guys can. And we can't deny that it's a problem, because it is. It's not gone away. It's never going to go away until we deal with it. And there's so many people willing to help and listen out there that you guys need to listen. And the physical therapies that doctors and nurses are telling you the truth. There's less than 1% that someone's going to come in here and defraud workers' comp. Trust me, because after they get done with you don't want nothing to do with workers' comp. And it's not. But God has made a difference in my life, you guys. And you guys can do the same thing. Do the job that you're supposed to do and do the best you can to help them people. Because physical therapy is where it's at. I know I got sent to Utah. Spent 7 months in the rehabilitation center. I got scars that connect all over my body. But I still get up every day and focus on what's wrong. And it's about, we got to help these people. And a lot of us come in with learning disabilities, and we don't have the disabilities that you guys have. So we have to struggle. And back in our day, they told us to lie because we had no other way. Back in our day, they did not help you. It was all about, well, go on. And you guys, it really does help, and I appreciate all that you guys have done and listened today. And I'm sure it made you hungry, because I'm sure but it stresses you too. And guys, don't forget about these people. They have a rough time. They're coming to you injured, and they're